We are switching gears very quickly here at the Law News Network. The end of the day now in the Luis Toledo case out of Florida. That's a defendant facing 3 murder charges related to the presumed deaths of his wife and her 2 children, ages 8 and 9. So while we wait for court to resume tomorrow, we have a little bit of time to discuss what's happened today. Will Bruzzo is a defense attorney in Orange County, California. He's joining us now on the Law News Network for a bit of perspective. Will, it's good to see you here on Law News.
Thank you. Thank you for having me.
So we're covering this case in Florida. The accusations are very, very difficult. You've got a young mother, 28 years old. You have a 9-year-old and 8-year-old. You have a defendant enduring hours and hours and hours of interrogation over a period of a couple of days, changing his story, attempting to commit suicide in the middle of it. And that's what today was really all about, was this suicide attempt. He gets up out of the interrogation room, says he has to go to the bathroom for like the 3rd time in a pretty short period. So there's a sense that something's up. Ultimately tries to barricade himself in the bathroom. He breaks the mirror. Tries to cut himself, and the way that police were able to rescue him is they had to run out to their squad car, get a battering ram. They try to bash the door down. They can't get the door down, so they wound up punching a hole in it and then reaching in with a taser and then tasing the defendant. And this all's in front of the jury now because the prosecutor is saying, look, it's evidence of guilt. Now, I'm curious, Will, what's your reaction to just this nugget of a scenario in the context of this case?
Well, the one thing it tells me off the bat is that the guy has a conscience and he feels really bad about what he did and bad enough to want to kill himself. And given the facts of this case, I can understand why he would feel that way. He went into some detail during his confession about the children and about looking into the eyes of the victims. And so, very clearly this weighs upon him. And for people who are not psychopaths, oftentimes this happens where a confession or the truth will bubble out over time simply because they have a conscience. And this guy, as horrible as this was, apparently feels pretty bad about it. In terms of bringing this in front of the jury, that's a tough one. I don't believe that they would probably need some kind of psychological expert to come in and indicate that. Quite frankly, I think they're muddying the waters if they try to bring that in. It doesn't seem like they're lacking for evidence in the least. I don't know why they would do that and set them up for being reversed on appeal and possibly having to do this whole horrible trial all over again. So I don't think it would be very wise, and I don't know if they would actually be able to get it in as proof of anything.
Well, it's in. I mean, the bottom line is that this is in. The jury is hearing that this guy tried to commit suicide, and the state is saying it's because there's consciousness of guilt, okay, as evidence that he indeed committed the crime. Because in the interrogation at various points, he's trying to blame the neighbor for killing the kids, but he eventually confessed in there somewhere to killing the wife, although earlier he claimed he didn't have anything to do with it. So it's interesting that you're looking at this from a evidence that he has a conscience theory, because the defense is saying, no, this isn't evidence of any guilt. This is just evidence that he is depressed over the loss of his family. So that's the way the defense is trying to color it. The state's trying to color it the other way. It almost sounds to me like your theory is the sort of theory that might save him from the death penalty.
I believe the defense is. I can see why they would spin it that way. They're trying to find a jury. They want the jury to find him not guilty. So I can certainly see why they would put it that way. My take on it is, given he confessed to the crime, at least when it came to the mother, I don't see how they're going to get around that. So I can see why the state would say this is a consciousness of guilt, just as, for example, fleeing the scene of a crime might be seen as consciousness of guilt. It's a very similar theory, but in 25 years of practice, I've never heard them using this as guilt of actually committing a crime, and I don't think it's very wise if they've already introduced that to the jury. It's in there, which means it can be appealed, and I think something like that is highly prejudicial to the potential outcome. So if I had been the prosecution, given I don't think that they need that evidence, I wouldn't have brought it in. I think that they are putting whatever verdict they get at risk there.
Well, that's an interesting viewpoint, but look, we've got a circumstantial case here. We don't have bodies. We do not have a body of the 28-year-old mother. We don't have a body of the 9-year-old daughter. We don't have a body of the 8-year-old son. And the defense has tried to bring up this corpus delicti issue, which is the legal term for not the body of a victim, but the body of the evidence, and saying, hey, look, you don't have bodies, you can't prove a murder happened. So the defense kind of dangles this theory out there that suggests that these three might still be alive and hiding somewhere. They dangle it out there, but they're afraid to go too far with it, because the bottom line is that her bank accounts haven't been touched. She left her car behind. She left all of her stuff behind, her purse, her phone. The kids' stuff all got left behind, and the defendant got caught by his neighbor throwing it in a trash receptacle or dumpster or something somewhere. So,
right.
How does the defense, if the defense is going to dangle this out there that a crime wasn't committed, then the state's going to keep trying to push its burden and say, hey, look, no, there is evidence of it. We've got all of this stuff. We've got the daughter's blood on the shoe. We've got the daughter's blood in the trunk mat of the car. It's the same car the defendant tried to ditch one county over in the early morning hours after this is said to have happened. And then we've got this suicide attempt, which, look, it's relevant. It does budge the evidence one way or the other, suggesting that something happened. I don't know as though I agree with the defense theory that this is just evidence of depression over the loss of his family. So,
yeah, the whole issue of the body, not being able to find the body, I think that's basically something that a decision for the court to make, because that is a legal decision, whether or not the prosecution has proven their case since they don't have a body. But I think the other circumstantial evidence, the finding the blood in the vehicle and that sort of thing, is probably enough for them to go forward in front of a jury. But quite frankly, in a case like this where you have a confession, I think it's a very good theory for the defense to argue, and I can understand why they would try to pursue it. Legally, it's well found that you have to have generally more than the confession of the defendant to prove a case. You need some other evidence. Of course, the prosecution has the blood, but generally, you want a body. You want to be able to show the jury, hey, we have a body. So I think it's a very good theory for them to argue. In the end, it's probably not going to succeed, but I can certainly see why they would argue it.
Yeah, I can see why they would argue it as well. I don't think it's going to go anywhere because, look, we've not only got the evidence of what happened here, but we've got the police reports from the 22nd of October, the day before the murders are alleged to have happened. And look, this guy's wife told police gave police this list of stuff that he had done to her. He had threatened to kill her, told her how, threatened her with a knife, he had strangled her, he had shoved her, he had grabbed her and held on to her. Then he shows up to her workplace and flips out there and slaps her in the face. So
there's a lot of evidence of violence.
There's a lot of stuff adding up against this guy.
Right. There's certainly a lot of evidence of violence, a lot of evidence of previous. I guess murder is the ultimate act of domestic violence, and so there's ample evidence of that previous. So I can certainly, a lot of things that point the finger to him. Of course, I think the confession is the most significant thing, and what his neighbor describes. Mr. Jackson, who apparently lived next door to him, actually drove out with him to dump the wife's car. He saw Mr. Toledo wiping down the car, essentially trying to wipe his prints and his DNA from the inside of the car. I think that's also going to be very convincing evidence. They also found the trunk mat where there was that he dumped, and Mr. Jackson saw that as well. It was interesting to me. You have two guys on probation. Mr. Toledo's on probation. His neighbor, Mr. Jackson, is on probation. Made Mr. Jackson hesitant to come forward to the authorities, and I think he was afraid of Mr. Toledo doing something to him. So it's interesting. You have these two guys on probation. One of them ended up, tipping off the police as to what happened, which it sounds to me like that's kind of what got the ball rolling, which led to Mr. Toledo's arrest and these charges coming forward.
Yeah, I would agree with that. I sensed from the neighbor, Mr. Jackson, that exactly that, a sense of fear, just the way he describes this car ride back. after ditching the wife's car and then later the children's belongings. Just, it was silence. And then at one point the defendant says, quote, "I snapped." Well,
right.
if somebody says that and they're in the car with you.
It only mean one thing.
Yeah,
right.
I mean,
and I said he was also a gang member. Is that correct?
There may be connections like that. I have not heard them testify to it directly, but if I'm recalling some of the pretrial evidence and discussions properly, that would make sense.
And apparently, with the news release I saw, that he was a member of the Latin Kings, and it could be that in addition to the fact he was acting so strangely, wiping down the vehicle, him being a gang member could have also made Mr. Jackson afraid that he was going to do something to him.
Yeah, now that you mention it, I think that there was some discussion that perhaps the vehicle was wiped down because there's some thought process, I guess, in the gang community that murdering children is a bad thing, so he didn't want any retribution from the gang. I do recall hearing some discussion that potentially that's what was going on, but look, the bottom line is today was all about this suicide attempt. We heard the recording, so they're in the interrogation room, they leave the interrogation room, they go out into the hallway and then into the nearby bathroom. We heard the recording in court today. I want to play it again. This is the sound and the lead up and ultimately the sound of what is said to have happened in that bathroom, the suicide attempt.
Hey, good to see you. Now! We're calling 911. Go, Kurt, get over here.
Detective Chefs, I'm going to pause it right here. We hear a lot of banging in the background. What is that we hear?
Well, at this time, Mr. Toledo slammed the door in the bathroom. The bathroom was an open indoor, and he was able to close the door on Investigator Ford.
Okay. And he's barricaded himself
And he barricaded himself in the bathroom.
The banging, what is that we hear?
The banging, at first, is us trying to make entry into that bathroom.
How so?
At first, it's by pushing and trying to kick the door in.
Okay. And we hear a lot of running around. What is that?
At some point, I leave to exit the building to go to my vehicle, and I have a battering ram and a taser in my vehicle. And
You brought those back?
Yeah, I obtain them, and I come back into the building.
Go ahead, I need you. Go. Break it. I got it. On the way. Everything okay out there? I locked myself in. Let me in there.
Were you and the other detectives eventually able to make entry into the bathroom?
Yes.
And what did you find once you were able to make entry into the bathroom?
Well, we weren't able to open the door at that time. We were able to put a hole in the door. We were able to tase him through the door, at which time it allowed us to push the door open, and we were able to drag him out.
Okay. So you were able to knock a hole in the door,
That's correct.
and you were able to take the taser, put it through the hole in the door, and tase the defendant through the door?
That's correct.
And after you were able to tase him, he was released his hold on the door, and you were able to make entry at that point?
That's correct.
Once you made entry into the door, into the bathroom, what?
Somehow he was able to break the mirror and was using the mirror to cut himself.
Where?
I believe he was cut his throat, and then he was cutting his lip.
I want to break out of that clip a little bit early because we heard most of the essence of it. You know, you can hear the police even with the battering ram as they testified, trying to break into that bathroom to get the defendant out of it. He's in there smashing the mirror, trying to cut himself with a glass. And again, prosecutors are trying to say that that is evidence of a guilty conscience, a guilty mental state. It's required for the charges they're trying to prove here. Do you think it'll work, Will?
I think it's ambiguous. I think the defense could easily spin that, and they could say, as you stated previously, he felt horrible about his children, or the children dying, or the wife dying, and maybe he felt they could also spin it to say that Jackson was actually the culprit, the neighbor, and that he failed to stop Jackson, and so he felt guilty about that, and that's why he wanted to kill himself. So it's just so ambiguous, and it can be interpreted so many different ways. I think it was a mistake to admit it. That's my 2 cents on it.
So you think the judge?
More, I don't think they needed it.
So you think the judge should have never even brought it in?
I just think it's too ambiguous to bring it in. Absolutely. And I don't know if the defense tried to do a motion eliminate to keep it out or what they tried to do, but just the ambiguous nature of it is such. I just think it's prejudicial and unnecessary.
Well, look, the state has its say on that particular piece of evidence. The defense is saying exactly, as we discussed before, the defense is saying, hey, look, the guy was depressed. He had lost his family. Right. And while we're there, let's talk about this. So at first the defendant is saying he's in the parking lot sleeping and he wakes up and, the wife's car is gone. Well, then when the neighbor comes forward, he's got to change his story because then he realizes they have the car. Okay. Right. And the kid's stuff from the trash receptacle. Okay. So he eventually says something along these lines. He says, my wife grabbed me by the throat, okay, and then I hit her and she died gasping for breath looking at me. Is he trying to make her out to be the first aggressor here, thinking that's going to get him off the hook somehow?
Yeah, obviously he's flailing. He's just flailing, trying to come up with some kind of response, some kind of explanation for this whole thing. And so, to me, that it's something kind of desperate. This is a very formidable individual, and to pin it on the wife, I think is kind of silly. But in his situation, when he's facing what he was facing, these were the things coming to his head. Not the most sophisticated guy, and God knows what other problems he has. But I think this is probably the best he could come up with. He had to come up with some kind of explanation.
Well, the truth would be a good one. And he says, he goes into detail about the deaths of the kids here as well. He, at one point, we were talking about this a second ago, he talks about feeling the one child's head and it's crushed.
He's feeling the broken skull bones is what he's describing.
Yeah.
And then he mentions he looks into the child's eyes, the female child's eyes, the last lingering moments of her life. It's a very disturbing case. This is and of course he claimed that the neighbor killed the children. I think the defense is still maintaining that, but he does admit that he was there at their very last moments. And admitted that.
Yeah, and that's what makes this a little bit bizarre, is he's trying to say that the neighbor's the one that actually did it. And, look, he was, I guess in his sort of twisted way of figuring this out, he was going to have to say that he at least was there, because at that point they presumably had the blood and the DNA evidence. And keep in mind that the house had been heavily cleaned. They said that you can keep in mind, they showed up within a couple of hours, because the mother of the wife knew that there was trouble the day before and in the weeks before, okay?
Right.
So the mother doesn't hear from the wife first thing in the morning and calls police and says, look, they got into a fight yesterday, he's threatened to kill her. She goes back home, tries to make peace with him, and now I can't get a hold of her. You need to get over there now and see what's up. So they show up pretty early on in the morning of October 23rd, 2013. The domestic violence complaint was the day before, after the workplace incident. Okay, so they're there really early in the morning. And they know she was alive at 1:03 a.m. up to at least about 1:15, 1:20, because that's when she hangs up on a phone call. Okay, the call goes out at 1:03 a.m. She's on the phone for 14 minutes and 13 seconds. So they've got her alive up to just about 1:15, 1:20. Okay. At that point, he shows up at his brother's house right after 5 a.m. So you got to figure everything happened between about 1:20 and about 5 a.m. All right. And so you
really have to say the mother's intuition here is amazing. The mother's intuition. She knew something was wrong. And I don't think she even waited for the police. She drove over there by herself, where she saw the neighbor, Mr. Jackson, and asked him about it. So I really have to say that's a very brave woman there, to go there knowing these problems were going on. She had the intuition to know something was wrong. She went there by herself and actually spoke with the neighbor, Mr. Jackson, who initially, deceived her as to what he knew about it. And I think that was probably just defensive on his part. But this says a lot about mother's intuition. It's too bad that things ended up in the worst possible way.
Well, it was probably some intuition. It probably was just the severity of the complaint the day before. As I said, the daughter's telling police, okay, and the mother backs it up. Hey, look, there have just been so many incidents of domestic violence between these two. The daughter had initially said to police on the 22nd she didn't want anything to do with the guy. They were planning to split up. She didn't want to be around him. She didn't want to go home with him, and that she was going to stay at her mother's, and that she didn't want the police to reveal her whereabouts. Okay, so she goes to the mother's after the workplace incident. At some point after that, he shows up at the mother's, probably figured out that's probably where she would be. Okay, and they're there for a while, and they try to mediate some kind of a deal that says, okay, well, you can stay in the house until you've got the money to move out, but we're splitting up. And at some point, she makes the decision to go back to the house to try to smooth things over. Right. And so the mother probably knew it just wasn't going to end well. So the mother probably tried to get a hold of her early. The mother said she did speak with her every morning by phone, and when the daughter didn't answer that call, the mother jumped into action. But look, one other topic that's been bugging me since the end of last week, I'll ask you what you think about it, Will. Florida is one of about half the states that do not have a mandatory arrest law in domestic violence situations. You're in California. California has a mandatory arrest law in domestic violence situations, but it depends on the severity, okay? It's not automatic when there's a report of it, which some states have. Some states are really, really strict with it. Do you think, because I tend to think that it would potentially have saved this family in this situation, but are you in favor of these mandatory arrest laws, or are you generally not in favor of them?
I think what you're saying is this case, the way it's ended up was essentially an escalation of domestic violence cases that you and I have seen, where it starts off relatively minor and just gets worse and worse and worse, and sometimes, in unfortunate cases, ends up in murder. California doesn't actually have a mandatory law. I think there's a sort of an informal policy with the police because they do arrest everyone. I've had cases, and this is no joke, I actually had a case where an individual was arrested for putting a cream pie in someone's face. So, it's really gone to the extreme. There was a time when I think police used discretion, and they would say to one party or the other, why don't you spend the night in a hotel and, take the night off and that sort of thing, separate the two. But then, it's gone to now in California, you're 100% accurate, there's always a party getting arrested. And sometimes it's very difficult to tell who the aggressor is. As far as my clients go, someone has to get arrested has not been good for them because they tend to get arrested and the bail's always set about $50,000, which is a lot of money. You have to put down 10% and you have to have collateral and this sort of thing. So for my clients, it has not been good. In terms of, is it helping, domestic violence situations so they don't end up where the Toledo case has ended? I haven't seen statistics on that. But, clearly it sends a message when these people are getting arrested and they're going to jail, some of them for the first time, they're getting booked, they have to bail out. If they can't bail out, they stay in custody. There's no question about it that when you hear the slam of the jail door behind you, that sends a message. And that is clearly what is behind the policy with domestic violence cases in California.
I did my double check. California has actually a discretionary arrest law, a pro-arrest policy, and mandatory arrest if there's a violation of a restraining order or something like that in a domestic violence situation. So it's one of the few states that actually uses sort of all the versions of it. Some states just say it's officer's discretion. And in Florida, that's kind of the way it goes. So I throw it out there. This is LawNewz. We ponder the outcomes of these things.
Right.
Would a different law have forced police to make the arrest on the 22nd? And would this mother and these two kids be alive on the 23rd and thereafter if the defendant had been, taken away from the situation and locked up immediately? We can sit and
California, it's the home of the O.J. Simpson case, the ultimate domestic violence case. It happened just an hour north of where I'm sitting now. So it's a very, very sensitive area of law for police, for district attorneys. As you know, the reason that domestic violence laws have become so forbidding is because a lot of these women, girlfriends, wives were ending up dead. And the result was that in California, at least, while the police still have discretion, as you stated accurately, essentially the policy or the unwritten law is that someone is getting arrested, and it happens every time. It could be that in this case, if they had arrested Mr. Toledo and taken him into custody and set bail, that he wouldn't have been able to make bail. If he hadn't bailed out, he would have had to stay in for a period of time until he saw a judge, usually at least within 48 hours, not including weekends. So it could have made a difference. It would be interesting to see some statistics on this because in California people are looking at how many people are incarcerated. In California, we have more people per capita incarcerated than any other state. In fact, than any other place. So California, we're having that discussion. Are there too many people in jail? Do we have to have policies that give law enforcement some more discretion, domestic violence programs, diversion programs, that kind of thing?
Yeah, and this is why I ponder these situations. I'm not in the business of doing legislative research, but I do know that there's a difference in laws among the various states. A lot of people do say what you said. If it's a mandatory arrest provision and somebody gets a pie in the face, to use your example, which will stick with me now
that happened
forever. Yeah, okay. Well, I'm look, truth is stranger than fiction. Something that, and we kind of laugh about it. Maybe we shouldn't, but. Look, it's much more silly sounding than what was alleged in this particular case. But a pie in the face in California leads to a mandatory arrest. A statement by a woman after she's been hit in the face, okay, with witnesses not to the strike but to the argument, saying that I've been threatened with a knife. He said he's going to kill me. He said how he plans to kill me. He's strangled me. He's shoved me. He's pushed me. All of this stuff, that does not lead to an arrest in Florida. So just look at the disparity between the two states. I think that's
there really is, and that may be a function of resources, or maybe people don't have as heightened a concern as we have in California.
Yeah, well, we can continue to ponder it. I point out the facts as I see them. So, Will Bruzzo, good to see you here on Law News, criminal defense attorney out of Orange County, California.
Thank you, sir.
Come back and see us again.